Today we're going to talk about trust planning, and this is an evolution from our last webinar, which we're going to talk about, which was core documents. Whenever we as estate planners hit a roadblock or we need to find a solution for estate planning purposes, so often that solution becomes a type of trust. So today, Aaron and I are going to walk through trust planning, and I'm Lou Pirot, one of your presenters, Aaron Connor. I do more of the planning side. Aaron does planning, but he also does more of the litigation side of the practice. So what I have found in 36 years of legal practice is the way to really learn how to plan is to learn what the problems are that give rise to litigation in estate and trust administration. And we do a lot of contested estates and contested trusts. Fortunately, we haven't drafted most of them, but sometimes family situations just come up that give rise to that. So today we're really going to explore how trusts work, what the various options are for trust planning, and how you can get started with a trust plan. This is our current slate of attorneys, and we are both in Albany, New York and New York City, and we're doing estate planning, elder law, estate and trust administration, business succession planning, and litigation in both guardianship and probate matters. Today's agenda, we're going to talk about the core four, just build on the platform, the foundation that we built from last session. Talk about revocable trusts, irrevocable trusts, asset protection for Medicaid purposes, what the tax motivations are and how tax management is done in trusts, and then talk about your next steps. So Aaron, the last session really covered this topic, but it's important for everyone, regardless of whether they have a trust, to have core documents in place. And these are that core four.
That's correct. These documents, generally speaking, will keep you out of court or your beneficiaries out of court, because at least the first three while you're alive, or first two. Because if you don't have a power of attorney or healthcare proxy, we have to litigate about who your agent is going to be. Just to review, your power of attorney is the one who makes financial decisions for you. It's a live document when it's signed. Your healthcare proxy is the person who makes medical decisions for you when you can. So you're making your own decisions up until a time when you cannot. You've appointed people there. Hopefully you've also done a living will either within the document or separately to give some direction. Disposition of remains seems like a fairly straightforward document, but stops arguments over where mom or dad or whomever is going to be buried and what their arrangements are. You would be surprised that that does tend to cause some angst sometimes.
And litigation. One of the cases that we talk about when we give other longer seminars and webinars is the case of Ted Williams. If you're a baseball fan, you remember he's the last man to hit 400. His son thought that his eyes were worth saving. So Ted Williams on his deathbed signed a handwritten piece of paper saying that he wanted to be cryogenically frozen. Whether he understood that or not is nobody really knows, but Ted Williams was decapitated. His head sits in a vat of liquid nitrogen, his body in another one in a laboratory in Arizona. Not where you want to be. So having clear direction, New York State gives us the document for that, the disposition of remains appointment, and then that's your body, but what about your property?
So your property goes according to a will, which has to go to court to be admitted to probate, to be determined to be your valid last will and testament. If you don't have a will, we still have to go to court and do what's called an administration. But the will at least appoints somebody to take care of what you're doing, gives direction about what goes to what person, and gives us a structure to accomplish all of those things. Much better to have it than not have it.
One common question that people ask is, well, when do I need an estate plan? And when do I need a will? And my glib answer is, tell me the day you're going to die, and I'll have you come in the day before, and we'll do the will, be very efficient. But nobody knows. And the point of these documents is they are advanced directives and documents that you put in place while you are healthy and able to do it with a clear mind and a clear vision of who you want as decision makers and how you want things to be handled for you when you can no longer make those decisions for yourself. We start this planning at age 18. When kids go to college, we give them a power of attorney and a healthcare proxy so that parents can deal with those issues. So we do have a 30-minute webinar that we did last month on the core four. So we're not going to talk much more about that. But Aaron, you do a lot of probate work. You do a lot of contests. Talk about the difference between a will and a trust from an administrative perspective.
Sure. So again, if you have a will, we have to file a probate petition with the court to get it validated. Okay, that does not exist with a trust. So the probate process is structured so where people have an issue, or where a beneficiary who's been cut out, or where there may be an estate going to people other than what we would say natural heirs, have the ability to come in and make noise and create a problem. With a trust, can that happen? It can, but it's much more difficult. Someone has to go out and plop down a retainer with an attorney. They have to file plenary action, meaning they have to go sue the trust to do something about it.
That's a different court sometimes.
Yeah, absolutely. And it's a much more intensive process, where the probate process, again, which is the process of validating a will, is built for people to come in, and a lot of times they do it pro se, meaning without an attorney, which can be a real nightmare for an estate to have to deal with.
So the other issue that we're all living with, thank God we're coming out of this, and congratulations to the government, which has put us on a track for vaccinations much faster than we had anticipated. So we're looking at maybe opening up as we go along to some semblance of normalcy in July. But the law practice also changed during the pandemic, some for the good, some for the bad. The good news is that we were able to do video document executions and video consultations. So our practice went virtual. We are still able to do that under a temporary order from the governor. We'll see whether that becomes permanent or not. We kind of hope that it does, because it gives people an opportunity to do things in their home. But the negative to this is that we have the ability now, or the necessity of going to court with courts that were closed for a portion of the pandemic and are still slowly reopening,
Yes.
operating virtually. But Aaron, the delays have become monumental.
Yes, probates, petitions, especially downstate, are very, very slow. Up here in the capital region, we've seen some courts are reopening. In fact, I was in court in person this morning, which is a nice thing. Some courts are still operating, though, virtually, so that's really a patchwork, but they're all very well behind, unfortunately.
And they have cut staffing. So the processes that used to take a couple of months now are taking 6 to 8 months. And every time you use a will, you are locked into court. A lot of clients come in there and think, oh, I have a will, I avoid probate. Your will is a piece of paper until a judge reviews it, approves it, issues an order admitting the will to probate, and gives the executor that you name under the will a certificate of letters testamentary. Until that certificate is issued by the court, the executor has zero authority to act on your behalf, which means that all of your assets are frozen. And so we're going to talk now about trusts and how trusts are utilized to alleviate that pain and to avoid that situation. And we'll talk about living trusts, because that's really where we want to focus. You can do trusts under a will. They're called testamentary trusts. But then that trust, the will has to go through probate, and that trust is subject to court jurisdiction on an ongoing basis. Why would you tie your heirs and your family into an ongoing court process? You can stay free of that using living trusts. We'll talk about the revocable versus irrevocable, putting retirement plan benefits in trust, life insurance in trust. Those are typically asset protection and tax motivated trusts. And then we'll also talk about Medicaid and special needs trusts. So Aaron, the most basic trust that we do for clients, but one that has enormous value, is the revocable trust.
Correct. So generally we're doing revocable trusts. Sometimes we're doing them in combination with an irrevocable trust. Other times we're doing them because people are at an asset level where Medicaid is not in the cards, or an income level, although even in those cases, we may do some Medicaid planning for them. Other times people have long-term care insurance, so we're protected from that long-term risk. Or sometimes people are not really concerned with protecting for Medicaid, but they want to make sure that they have a plan. They want to stay out of probate. They want to do things downstream. What do we mean by that? We mean creating trusts for their kids or whoever their beneficiaries are to protect that wealth long-term, which is really easy to do in a trust. Basically, in a revocable trust, everything goes in other than a tax-deferred retirement account. There's no reason to leave a checking account out, to leave property out, to leave business interests out. The revocable trust is you being you, or you and your spouse being you. It's still tax reported the same way. So there really is no benefit to leaving anything outside of a revocable trust other than your tax-deferred retirement accounts.
And this is your alter ego. So when you set this up, there are three hats in a trust, three different roles that are played in various trusts. One is the role of the grantor, which you see there, and you're the one who's creating the trust. And as Aaron said, everything except your IRA, 401k, qualified retirement account can get retitled and should get retitled into the name of the trust. The second hat is worn by the trustee, and that's the person that manages the assets that are inside the trust, and that's you. And the third is the hat of the beneficiary. And the beneficiary of a revocable trust is you. It could also be your children and grandchildren or whomever you want to build in, but this is a trust that you create for your own benefit that you're the trustee of. And you might say, well, why do I do that? The revocable trust is a contingency plan, and there are two major contingencies, both of which can land you in court.
Well, I mean, I'm not sure exactly what, but assets left outside of your revocable trust will land you in court because they will go through the probate process.
And during lifetime, if you happen to lose capacity,
Yes,
that's another time. And you also do a lot of guardianship work.
correct.
And in many cases, it's because there is no contingency plan.
That's right. So if you don't have a trust and you don't have a power of attorney, you don't have a healthcare proxy, or you only have a healthcare proxy or you only have a power of attorney, we can end up going to guardianship court. All right. Generally speaking, if you don't have those documents and you don't have a revocable trust, you haven't set up a plan for someone to deal with things when you become incapacitated. And a revocable trust can really insulate the need for any of that because you're going to name a backup trustee. You're going to name probably a backup to the backup. You're going to have direction about how things are going to be handled during your incapacity.
So the revocable trust allows you to create a long-term plan. You create it today, you fund it today, you transfer your assets, we deed properties in, we put bank accounts, brokerage accounts, business interests, annuities, stocks, bonds, all of that goes into the trust. If you become incapacitated, your successor trustee simply steps in and follows your guidance. You create the terms of the trust. How do you want the money invested? How do you want it used? Who do you want to benefit from it during your lifetime? But the trust doesn't end there, or it doesn't have to. Some trusts simply say that upon my death, it pours out to my beneficiaries, my children and grandchildren. But more and more frequently, we are taking the next step and extending that trust on for the next generation. And I know, Aaron, that I work hard. I work
Yes,
damn hard.
There's no doubt about that.
I want to keep what I have in my family.
Mhm.
And I trust my kids. I think that they're all great and very bright, but who knows what's going to happen to them when they get married, when their businesses may fail, when they may get sued. I want to insulate my wealth, give it to my children, let them control it, let them manage it, let them use it, but not have anyone else be able to penetrate that lockbox. And this is called a beneficiary control trust. We have some variations. The bloodline trust means my children cannot put it in anyone else's hands except my descendants. And any trust, the revocable trust in particular, the Medicaid trust, we'll talk about them all. This is what happens at the time of the grantor's death. We simply continue the trust on. Instead of paying the money out, we divide it up. Each of the beneficiaries gets their own trust. It depends on what the beneficiary's condition is. I call it the trust meter. Do you trust your children implicitly and say, I would leave it to them outright, but I want to protect them and have it protected from their creditors, from divorces, from other lawsuits. But I would otherwise give them full authority all the way over to my child can't handle anything and I need someone else to manage it. These trusts, these sub-trusts after your trust, which again are free of court supervision, can be structured individually. And you may have the brightest child in the world, and that's the beneficiary control trust. You want to give them free reign. You may have a child that has gambling problems, drug problems, spendthrift problems. You may want to have that trust fully protected for them from themselves and those other people. And we also deal a lot with special needs, and we'll talk about that in a bit. Special needs children require special needs trusts, and you can make that part of your own trust plan in addition to being able to do it in a standalone trust. But it's important, Aaron, for downstream planning and the current planning, when we use trusts, that people coordinate their assets. And this is probably the most common mistake that people make.
Absolutely. So if you've created these beneficiary control trusts for your children And a lot of your wealth is in that tax deferred retirement account, which we're going to leave out of a trust, and you name them individually as beneficiaries, well, they're going to be able to get that money very quickly. Most of them are going to cash it in immediately, pay a lot of tax, and then do whatever they want with it, give it to their wife, give it, spend it on things that don't make sense. So you really need to make sure that you're looking at all the beneficiaries on the assets outside of the trust to make sure that they match what you're doing inside the trust.
So in the process of trust planning, the first thing you're going to do is choose who you want to be successor trustees or trustees currently in an irrevocable trust, who the beneficiaries are going to be currently during your lifetime, who the beneficiaries are going to be ultimately, how are you going to structure those benefits. But we also, and when we send our questionnaire out, I was on the phone this morning with a client, said, yeah, I got this 16-page document. What do I do with this? And we send out a very thorough and comprehensive questionnaire, and this is why. Because if we miss something, if you don't report an asset to us and we don't help you get it into the trust, then that trust is not effective. It's not going to protect that asset and make it integrate with the rest of your planning. So it is important for you to take an inventory at the time we start this planning, and we give you that questionnaire. It's on our website. You can get it anytime. We're happy to email it to you if you want to email us. But that questionnaire is really the launching point for this planning, and it gathers up all of the information and documentation that we need in order to put a comprehensive plan together for you. This isn't just a document that you pull off the shelf. This is a plan that requires you to integrate all of your assets. And it's doing it now because in probate, Aaron, this takes years, and there is a lot of anguish trying to do all of this when the person is deceased. Nobody has records, nobody knows where the assets are.
Sure.
And we go about that process, but it's painful sometimes.
Well, and especially with IRAs, if you don't have a beneficiary on them, or you're the surviving spouse and there's no secondary beneficiary, if they have to be paid over to an estate, you've lost a lot of wiggle room and you're paying a lot more money than you need to. So making sure that beneficiary designations are up to date is a big part of what we're doing.
So the one downside to a revocable living trust is that if you do need care in the future, and I'm talking now about long-term care, whether it be home health care or assisted living or nursing home care, if you need that type of care in the future, your assets are available to you in a revocable trust. It doesn't give you that layer of asset protection. The trust you create for your children does. They're fully Medicaid asset protected as well. But for yourself, if you're doing a revocable trust, those are still your assets. Medicaid is a complex program. We have a 5-part series that you can access that talks about the Medicaid program and how it works in New York State. It's on our website. And when you look at Medicaid, they only allow you to keep $15,900. So how do I plan in advance if I don't have long-term care insurance? Medicare doesn't cover this. You have to take my word for that. Medicare is not a player in long-term care. So the only other program that you can utilize is Medicaid, which has that $15,900 limitation. But you can create a trust in advance, either buying insurance, which you could do a revocable trust if you have sufficient insurance coverage. But if you don't, then we can supplement your plan with an irrevocable Medicaid asset protection trust. And when we do this planning, we have to ask 3 questions. If I do need care, where do I want to live? Do I want to hunker down in my own home? And that's probably 95% of the people we talk to want to stay in their own home. We help with that. That's our passion, is keeping people independent in their own home. You might want to go to a nice continuing care retirement community or a nice independent living community where they have supportive services. Where you want to live is first question. Who's going to provide services to you? Who's going to take care of you? And how are you going to get the services that you need? If it's in your home, again, you need a plan for that. And finally, how would you pay for it? The only 3 ways to pay for long-term care, notice Medicare is not on this screen, are Medicaid, private insurance, and self-insurance. And the cost, Aaron, has just gone through the roof. $180,000 is the average nursing home cost per year, $15,000 per month. And if you need 24-hour-a-day home health care, it's more. It can be $200,000, $250,000 per year for 24/7 round-the-clock care. How many people can afford that? And if you can't, then Medicaid requires you to get out in front of this, and there are look-back periods that apply.
Absolutely. So if you're going to a nursing home or a chronic care, as it's known. You have to get your assets out 5 years ahead of time if you want to protect everything that you have. Okay, right now for home care, we have a very limited window left of no look back here in New York State. Okay, we're 99% certain that January 1st, 2022, the rules are finally going to be implemented, putting the look back in. This was passed, supposed to take effect in October of this past year, but due to the pandemic, that date had been pushed farther and farther out. But it looks like January 1, 2022 is going to be the date. So you need to be mindful of that. You want to get out in front of it because the rules aren't going to get better, and you want to get grandfathered into the old rules.
So the question becomes, Aaron, how do you get out in front of this? How do I create a plan now that allows me to shelter assets? And if I need it 5 years from now or 2.5 years from now, Medicaid would be available to me. And the answer is our Swiss Army knife, a trust. And so this is an irrevocable trust. And there are some limitations on who can be the trustee and who can get the principal.
That's right. So we don't subscribe to the theory that someone can be the grantor can be the trustee of this irrevocable trust. We're seeing more and more attacks on trust. So we want to make sure that you get the protection you're looking for. You need to appoint someone else, whether that's a son or daughter, niece or nephew, your friend, anybody other than you and your spouse. Also, once assets are in this trust, principal cannot go directly out to the grantor or grantors. Income can. So if there is an investment account in here throwing off dividends, you can collect those if you want to. But principal can only be distributed out to the remainder people or the beneficiaries, the lifetime beneficiaries, whoever we choose for that purpose. They can take money out and get it around back to you. That all has to be done very carefully, but you're getting protection here, but you do have some ability to access things when you need them.
So what goes into a Medicaid asset protection trust? Your home, bank accounts, stocks, bonds, annuities, life insurance, business, real estate. The amount of funding really depends upon the situation that you're in. Do you need care now? We use these trusts for people that need immediate Medicaid. We put a certain amount of their assets in. For home care, that can be all of your assets. But for nursing home care, maybe half, and then we'll use the other half to private pay for care. Call it the rule of halves. We can still protect things even if you're on the doorstep of the nursing home. But for home care right now, until January 1, we have the ability to create the trust and be Medicaid eligible the next month. I keep the income from my trust. So dividends, interest, rents, annuity payments, all those things keep flowing back to me. The principal, as Aaron said, can't come back to me directly, but I have 3 children. If you're in a situation where you have children or nieces, nephews, or whoever your beneficiaries are, brothers, sisters, they can take money out of the trust. Once they take the money out, there's no restriction on what they do with it, and they could in fact use it to pay bills on your behalf. So by doing that, your trustee and beneficiaries can pull money from the trust, and it can then, in their discretion, be used back for your benefit. So that is how we structure the trust to keep access, keep income, keep control. And Aaron, there are other safeguards that we build in to keep it real for people so that they have a comfort level.
That's right. So even though the trust is irrevocable, you can change your trustee at any time. So if there's something that impacts the relationship between you and the trustee, you can knock them out and appoint somebody new. The bigger stick is that you can change your beneficiary at any time or beneficiaries. So if someone goes off the rails and you don't want to leave them money or you want to diminish their share, you have the full ability to do that. And even though it's an irrevocable trust, because we draft it carefully, it can be revoked. So you really have all the power and all the protection if you engage in this plan.
So it has a tremendous amount of flexibility. We try to balance out the needs of the grantor, whoever is creating the trust, to make sure that they feel comfortable, that they have enough cash in bank accounts. And remember, 2 things about the IRA. It cannot go into your trust because that's a taxable event. But in New York State, it doesn't have to, because if your IRA is paying you periodic payments, and that could be your RMDs at age 72, or it could be voluntary withdrawals earlier than age 72, that IRA is exempt. That applies to 401ks and 403bs and all the rest. And if you're drawing the money, you could have $1 million in an IRA. That asset is not a countable asset if you're drawing income based upon the appropriate tables. So all important things to remember. Revocable trusts, irrevocable trusts for Medicaid purposes are the two primary trusts that we do for clients. And usually it comes down to a balancing act. What are your needs? What's your age? What are your current resources? And then you're going to have a customized trust document that fits your needs. I mentioned earlier that when we deal with people with special needs, whether they're creating a trust for themselves, we call that a first party special needs trust, or we're creating a trust for a child, there are excellent opportunities to protect assets, shield them, keep the money available to that person with a disability, and yet have that trust still be effective to create Medicaid and SSI eligibility. And these are great for anybody with a special needs family member.
Absolutely, and we encourage people not to cut people out because they have a special need and leave all the money to the other child or that kind of thing. That's not a good plan, and we can talk more about that on a different day, but use a special needs trust if you have a special needs person.
So we get into more esoteric types of trusts. We do offshore trusts for people who want true asset protection. We do a lot of trusts in Delaware because Delaware offers a tremendous amount of advantages, sometimes Nevada, South Dakota, states built for trust law. And we do trusts for tax motivated planning as well. So we have a lot of tax law changes on the horizon. What's going to happen, no one knows, but preparing and having a trust drafted properly to take advantage of the current tax environment. And these are just the income taxes that we're all subject to. If you're in a New York City situation, you're paying 37, 8.82, and then 3.6 New York City tax. If it's net investment income over a certain threshold, you pay another 3.8%. So you get the idea. And these tax rates are all going up. So as we're doing planning, we're also looking at capital gains tax because they're talking about putting a new tax on capital gains for high net worth people, high income earners, going up to 39.6%. Right now, the top rate is 20, and eliminating step up in basis at death. So when we design a trust, we are cognizant of all of these tax rules, and we're putting the provisions in play that will allow you to minimize tax while maximizing the benefit to you from that trust. You may have heard that there are proposals to change the estate and gift tax. Right now, we have very, very high thresholds. Federal is $11.7 million, New York $5.93 million. If you are a high net worth individual with those kinds of assets, then you need a plan, because there are opportunities today to eliminate federal estate tax, to eliminate New York State estate tax. We have a whole panoply of trusts. I'm not going to go into all of those at this point, but suffice it to say, a lot of my day is spent creating trust plans for clients who do have situations both for asset protection, whether it's Medicaid or potential liabilities, and tax planning purposes. There are boundless opportunities to do planning in this realm today. Those opportunities may not be there tomorrow, so it's a good time to act. And for those unaware, and I have had a lot of clients coming in that didn't hear about the Secure Act. This passed during the Trump administration, went into effect on January 1 of 2020. When you inherit an IRA now, you can't stretch it over your lifetime, other than a spouse. You have to now pay it over 10 years, or draw it out over 10 years and pay the tax over a 10-year time period. So if you're like many of our clients and the IRA 401k is the major component in your estate plan, that requires special consideration. We can still make that payable to a trust, but we have to really balance out the tax planning within that trust very, very carefully. So we have a lot of resources, Aaron.
We do. We have great guides. We have a lot of videos. We have blogs. We have webinars. They're all available, linked through our website. So if there's a topic that we didn't cover today that you're interested in, we encourage you to go there, review that, and reach out to us if you have questions or want to do some planning.